Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, in a notable ruling, a Constitution bench of Supreme Court ruled that direct evidence of demand of bribe is not necessary for conviction under Prevention of Corruption Act and circumstantial evidence will be suffice. The five-judge Constitution bench, consisting of Justice Abdul Nazir, Justice B.R. Gawai, Justice A.S. Bopanna, Justice V. Subramanian and Justice B.V. Nagaratna opined that even if the direct evidence of the complainant is not available owing to debt or other reasons, there can be conviction of the public servant under the PC Act if the demand for illegal gratification is proved through inferential evidence based on circumstances. Presumption of fact with regard to the demand of acceptance may be made by a court of law by way of an inference only when foundational facts have been proved, the bench ruled. Another Constitution bench comprising of 5 judges held that if summoning order is passed either after the order or acquittal imposing sentence in the case of conviction, the same will not be sustainable. The court observed that the summoning order has to be precede the conclusion of the trial by imposition of sentence in the case of the conviction. If the order is passed on the same day, it will have to be examined on the facts and circumstances of each case, and if summoning order is passed either after order of acquittal or imposing sentence in the case of a conviction, the same will not be sustainable enough. Observing that a female tribal is entitled to parity with male tribal in interstate succession, the Supreme Court has directed the Centre to examine the issue and consider amending the provisions of the Hindu Succession Act so as to make it applicable to the members of the scheduled tribes. The top court said when the daughter belonging to the known tribal is entitled to equal share in the property of her father, there is no reason to deny such a right to the daughter of tribal communities. As per Section 2.2 of the Hindu Succession Act, it will not be applicable to the members of scheduled tribe. A bench of Justice M.R. Shah and Justice Krishna Murari said that there is no justification for denying the right of survivorship, a right of a person to property on the death of another having a joint interest, so far as the female member of the scheduled tribes are concerned. The Apex Court has stayed an order of the National Green Tribunal to phase out all public transport vehicle with BS4 Bharat stage engines and below in the next 6 months. A bench of Justice S.K. Cole and Justice Abhay S. Oka issued notice to the parties in case and so their replies on the appeal filed by the West Bengal government. The entity in its order has said that state government must ensure that public transport vehicle with BS4 engines and below are phased out in 6 months so that only BS6 vehicles ply in the state, including Kolkata and Howrah thereafter. The division judge bench of Justice Sanjay Kishan Kaul and Justice Abhay S. Oka of the Supreme Court has held that in view of Section 157 of the Indian Evidence Act 1872, the dying declaration can be treated as a formal statement and therefore can be used for contradicting the witness. Another division judge bench of Justice Krishna Murari and Justice S. Ravindra Bhatt has held that in a case relating to motor accident claims, the claimant are not required to prove the case as it is required to be done in criminal trial, and that court must keep this distinction in mind while dealing with cases under Motor Vehicle Act. Next we have Delhi High Court. The Delhi High Court has ruled that signboards could be seen as advertisement if they in any way convey via their name or nomenclature nature of the business. The division judge bench of Justice Rajiv Shakder and Justice Tara Vista Ganju observed that Section 143 of the DMC Act adverts to the expression advertisement, which is nothing but a mode of communication directed toward the public at large or a particular set of people or customers to inter alia convey kind of business the advertiser is involved in and to promote its business and commercial interest. The Delhi High Court has directed the Delhi government to ensure strict compliance of prohibition of electronic cigarettes production, manufacture, import, export, transport, sale, distribution, storage and Advertisement Act 2019. A division judge bench comprising of Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad has in this view asked the authorities to conduct periodic checks of areas and specially make sure that e-cigarettes don't get sold near and around schools and colleges in the national capital of Delhi. The High Court of Delhi has said that it would pass an order on public interest litigation against the permission accorded to Sikhs to carry kirpans while travelling on civilian flights in India. The petitioner, a lawyer, had challenged a March 4, 2022 notification by the centre which has said that sick passengers shall have exceptional regulatory sanction to carry kirpans having blade length of no more than 6 inches and total length of no more than 9 inches while on board any civilian flight in India operating on all domestic routes. The Delhi High Court, while advising that hyper-technical approach should be avoided while applying a scholarship scheme, ruled that a meritorious candidate cannot be deprived of scholarship due to mere discrepancy in filing of the income tax return instead of the income certificate. A single-judge bench of Justice Pratibha M. Singh was of the view that since the two documents evidence the same parameters of income requirements, it cannot be lead to a situation where an eligible meritorious candidate is deprived of the scholarship. Now let's have an overview of other high courts. The Kerala High Court has struck down a provision of the Divorce Act 1869 applicable to Christians that mandated a minimum of 1 year of separation before applying for divorce by mutual consent. And now the court has gone further with the verdict. This brings the law further on par with other laws that govern matrimony and divorce among other communities, such as the Hindu Marriage Act. Those acts allow courts to entertain mutual consent divorce petitions before 1 year has lapsed since marriage, so there can be this 1 year period in the Divorce Act alone. This is essentially what the court has ruled. The Punjab and Haryana High Court has held that the report of FSL forms the foundation of the case of prosecution in an NDPS Act matter, and in case the same is not there, the entire case of the prosecution falls to the ground. The court has held that a case under the NDPS Act can only survive in the case of prosecution if it is able to establish that the article recovered is indeed a contraband and which can only be established on the basis of its chemical examination, which is normally done through FSL established by the government. The Madras High Court has dismissed a contempt of court petition filed against a family court judge for not disposing of a divorce case within a stipulated period of time and has also imposed a cost of Rs 50,000 on the petitioner. The single judge bench said only the litigant was responsible for delay in disposal of the divorce petition. Further, referring to the limitation period prescribed under Section 22 of the Contempt of Courts Act 1971, the judge said if at any contempt has been made out, such a petition should have been filed within a year. The Bombay High Court, while allowing a guardianship petition filed by biological parents, opined that branding a child as illegitimate amounts to harassment. The single-judge bench of Justice Manish Pitale, while adjudicating upon a petition under the provisions of the Guardians and Wards Act 1890 seeking various reliefs, observed that petitioners, being the biological parents of the child, it would be a travesty of justice if the prayers are not considered, merely because the personal law applicable to the minor child indicates that being an illegitimate child, she has no rights towards inheritance or descent. The Jammu and Kashmir High Court observed that the specially able people must be treated with respect and honour, not in any way that they are treated as liabilities. Certain directives such as facilities like constructed ramps, wheelchairs and raised and special washrooms etc. are to be ensured by the centre. It was also ordered that any statement of the specially able persons to be recorded by the police must be done at the place of convenience or residence of the specially able people. Moving on to miscellaneous news. Chief Justice of India D.Y. Chandrachud has noted that it is high time for the legislature to consider growing concern around the age of consent under the Protection of Children from Sexual Offences Act. The current age of 18 poses a difficult question for judges dealing with cases involving adults in relationships, he said. The CJI highlighted the issue in his keynote address at a 2-day national consultation on the POSCO Act organized by the Supreme Court Committee on Juvenile Justice in association with the UNICEF. The All India Bar Examinations 17 will be held on 5th February 2023, the Bar Council of India has announced. The Supreme Court has sought the centre's response to a plea by the National Commission of Women seeking a uniform age for marriage for women irrespective of their religion or personal laws. A bench headed by CJI D.Y. Chandrachud has issued a notice to the centre in a petition seeking an increase in the marriageable age under the Muslim personal law to bring it in consonance with prevailing laws in India. The NCW has prayed for directions to make 18 years the marriageable age for all girls and women of all communities, irrespective of their religion. It pointed out that the minimum age of marriage under various personal laws is consistent with the prevailing penal laws, except in the Muslim personal law. Yet another High Court has added its name to the list of ones preferring live streaming of proceedings. The Kohima bench of the Guwahati High Court has become the third constitutional court from the northeast to live stream its proceedings after Guwahati Principal Bench and Meghalaya High Court. In a notable move, the Bar Council of India has suspended the license of 29 practicing advocates, including President of the District Bar Association, Sambhalpur, for 18 months. This is in response to the striking advocates in collusion with the local public indulging in shouting slogans, burning effigies of judges and office bearers of the Bar Council of India and State Bar Council, entering in the courtrooms and damaging the computer sets and properties inside the court and further manhandling the police officers and personnel, fighting and abusing them. Aftab Poonawalla, accused of strangulating his live-in partner Shraddha Walker and chopping her body into pieces, has filed for bail in a Delhi court. As the initial investigation in the case is completed and the charge sheet is yet to be filed, there is no purpose in keeping the accused in judicial custody, his lawyer has argued. CJI D.Y. Chandrachud has announced that no Supreme Court bench will be available from December 17th till January 1st during the ensuing winter vacations. This assumes significance in wake of Union Law Minister Kiran Rijiju's statement in Rajya Sabha, in which he said that there was a feeling among the people that long court vacations were not very convenient for justice seekers. In the end, we have international news. United States President Joe Biden has signed the Respect for Marriage Act into law, which aims at safeguarding the rights and protection of same-sex and interracial couples. The act was signed against the backdrop of growing concern over gender rights in the country, from the overturning of Roe vs. Wade in June to the Colorado Springs shooting last month. New Zealand has passed a landmark legislation prohibiting younger generation, that is anyone born after 2008, from buying cigarettes. Health Minister Aisha Varel, who introduced the bill, said it is a step forward towards a smoke-free future. The Singapore High Court has opined that an award passed by a foreign seat emergency arbitrator is enforceable under Singapore International Arbitration Act 1994. It was observed that the term arbitral tribunal is not defined in Section 27 or anywhere in Part 3 of IIA, and therefore it can be interpreted to include emergency arbitrators. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box. And for weekly updates, like and subscribe to our channel.